Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, any views and opinions expressed in this podcast are those of the podcast creator alone and do not reflect or represent the views, positions, or policies of any organization, institution, or entity, past, present, or future, with which the creator is or may be affiliated.
Welcome to The Deep Dive, your shortcut to getting truly informed. We dive right into the source material, pull out what matters, and give it straight to you. Today, we are getting into the weeds of patent law, specifically this concept called prior art, and a really critical rule known as the on-sale bar. There's this pivotal Supreme Court case we need to unpack. It decided whether, making a confidential sale to a partner can actually kill your patent later on. This all comes under the Leahy-Smith America Invents Act, the AIA. So let's break down this conflict.
Right. We're looking at Helsinn Healthcare SA versus Teva Pharmaceuticals USA, Inc. That's case number 17-129 in the Supreme Court of the United States. The decision came down on January 22nd, 2019. It was argued a bit earlier, December 4th, 2018.
Okay.
Importantly, it was unanimous. Justice Thomas delivered the opinion for the entire court. Helsinn Healthcare was the petitioner, and Teva Pharmaceuticals the respondent.
Unanimous. That's always significant. So what was the core legal question they had to wrestle with?
It really boils down to one thing, question 3 in the grant, essentially. Does selling your invention to someone else, even if they promise to keep it secret under contract, count as putting it on sale under the AIA? Specifically, Section 102A1. And this is where it gets really interesting because the answer impacts that fundamental choice inventors face. Do you partner up early or do you lock down the patent first?
Okay, so to get why this was such a fight, we need the backstory, the facts, the timeline. What was the invention?
Sure. The product was Aloxi. It's a drug used to treat nausea and vomiting caused by chemotherapy. The key chemical is palonosetron. But the patent claims weren't just about the chemical, they were very specific. A fixed dose of 0.25 milligrams in a 5 milliliter solution. That specific formulation.
Got it. And Helsinn didn't want to go it alone, right? They partnered up.
Yeah, exactly. Back in early 2001, so well before the critical date we'll get to, Helsinn signed 2 big agreements with another company, MGI Pharma. One was a license agreement, the other a supply and purchase agreement. Basically, MGI got the rights to distribute and sell Aloxi, including that specific 0.25 milligram dose, in the U.S.
Okay, but here's the twist, right? The confidentiality.
That's the crucial detail, yes. The agreements explicitly required MGI Pharma to keep all the proprietary information they received confidential. So you have this commercial deal, MGI is set to sell the product, but the specific recipe, that 0.25 milligram dose, was meant to be kept under wraps.
But the deal itself wasn't totally secret, was it? Didn't they announce something?
They did. Helsinn and MGI put out a joint press release, and MGI, being a public company, also filed a Form 8K with the SEC about the agreements. But, and this is key, neither that press release nor the SEC filing actually mentioned the 0.25 milligram dosage. They announced the partnership, but not the secret sauce, essentially.
Right, so the existence of a sale or license was public, but the details of the invention weren't.
Precisely. And remember the timing. These agreements were signed in early 2001. Helsinn didn't file its provisional patent application covering those doses until January 30th, 2003.
More than a year later.
Way more than a year later. And that's where Teva comes in. Teva, wanting to make a generic version, challenged the patent, arguing that those 2001 deals with MGI put the invention on sale too early, violating the 1-year grace period.
Which brings us to the legal clash itself. The AIA statute, Section 102A1, says you can't get a patent if the invention was in public use, on sale, or otherwise available to the public, more than a year before you file. And the whole fight seemed to hang on those last few words, or otherwise available to the public.
That phrase was everything. Before the AIA updated the law in 2011, court precedent was pretty clear that even secret confidential sales could trigger the on-sale bar. The big question was, did Congress mean to change that established rule when they added that phrase?
So Helsinn, the patent holder, what was their main argument? How did they interpret that new language?
Helsinn argued, quite logically on the surface, that yes, Congress did change the rule. They claimed that adding, or otherwise available to the public, acts as a catch-all qualifier for the whole section. Meaning, any of the triggering conditions, public use, being on sale now, had to also make the invention somehow publicly accessible.
Okay, so their logic was MGI was bound by confidentiality, the public announcements didn't spill the beans on the 0.25 milligram dose, therefore the invention wasn't publicly available, and the on-sale bar shouldn't apply under this new AIA standard.
Exactly. They saw that new phrase as their way out, arguing the nature of the sale mattered, specifically its secrecy regarding the invention's details.
Makes sense. So what was Teva's counter? Why did they think the patent was invalid?
Teva argued for sticking with the historical interpretation. Their position was straightforward. A commercial sale is a commercial sale. They said that the act of selling the invention or offering it for sale commercially to a third party like MGI triggers the 1-year clock, period, regardless of confidentiality agreements.
So the secrecy didn't matter to them?
Not for triggering the bar. They argued the fact that Helsinn was commercially exploiting the invention through the MGI deal back in 2001 was enough. The public nature of the sale's existence, via the press release and SEC filing, combined with the commercial transaction itself was the trigger, not whether the specific dosage became public knowledge then.
And the lower courts couldn't agree on this.
Right. It was a split decision initially. The district court actually sided with Helsinn first. They bought the argument that because the crucial 0.25 milligram dose wasn't publicly disclosed, the confidentiality saved it.
Okay.
But then the Federal Circuit Court, which specializes in patent law, reversed that. They said, no, if the existence of a commercial sale is public knowledge, which it was here, you don't need the specific nitty-gritty details of the invention to be disclosed in that sale announcement to trigger the bar.
So a real back and forth, which leads us to the Supreme Court. What was the final verdict?
The Supreme Court sided with Teva and affirmed the Federal Circuit's decision. They held that, yes, a commercial sale to a third party, even one bound by a confidentiality agreement, does trigger the on-sale bar under the AIA. Helsinn's patent related to that specific claim was invalid because of the MGI deal over a year before filing.
Okay, now let's really dig into the why, the court's reasoning. Why stick with the old interpretation despite the new statutory language?
The absolute core of their reasoning, the linchpin, was this legal principle called the presumption of reenactment.
Okay, what's that?
It's a rule of statutory interpretation. It basically says that if Congress uses language in a new law that already has a long-standing, well-understood meaning from previous court decisions, courts should assume Congress intended to keep that same meaning.
So the phrase on sale had a history. The court felt Congress knew that history when they put it in the AIA.
Precisely. They're saying Congress didn't just pluck on sale out of thin air. It had decades of judicial construction behind it. The court pointed heavily to its own prior ruling in Pfaff v. Wells Electronics back in 1998.
What did Pfaff establish?
Pfaff defined what on sale meant under the pre-AIA law. It set out two conditions. One, the invention had to be the subject of a commercial offer for sale, and two, the invention had to be ready for patenting. Crucially, the Pfaff decision didn't say the sale itself had to make the invention's details public. The commercial nature and readiness were enough.
And they looked beyond just Pfaff.
Oh, yes. They also noted that the Federal Circuit, for years leading up to the AIA, had consistently held that secret sales, like maybe to a supplier or distributor under an NDA, could invalidate a patent. They cited cases like Special Devices v. OEA. So the understanding that commercial exploitation, even confidential commercial exploitation, started the clock was really settled law before Congress acted in 2011.
Okay, so the court felt the meaning of on sale was rock solid. But what about Helsinn's argument regarding or otherwise available to the public? Didn't that change anything?
The court essentially said, no, they didn't buy that Congress intended those 5 words to quietly overturn decades of established precedent on what on sale meant.
How did they phrase it?
Justice Thomas, writing for the court, called adding that phrase a too oblique way to make such a massive change to the settled meaning of on sale.
Too oblique. That's pretty direct judicial language. Basically saying, if you wanted to change the rule, Congress, you needed to be much clearer about it.
That's exactly the implication.
Yeah.
The court saw, or otherwise available to the public, as a catch-all category for other types of public disclosures that might not fit neatly into published use or on sale. Think maybe like a publicly accessible database entry or something novel. But they said it doesn't redefine or limit the existing independent meanings of public use or on sale. Each term still stands on its own based on its historical interpretation.
So this wasn't just about reading the words, was it? It seems tied to the whole point of having patent law in the first place.
Absolutely. The court connected it back to the policy behind the on-sale bar. It's there to prevent inventors from gaming the system. You can't commercially exploit your invention for years, testing the market, making money, essentially extending your monopoly period indefinitely, and then decide to file for a patent once it's proven successful. The 1-year grace period is supposed to be just that, a grace period, not a market testing extension.
Right, it prevents pulling something back from the public domain after you've already started selling it.
Exactly. That commercial activity with MGI, even though confidential in its specifics, was commercial exploitation. It started the clock.
And the fact that it was unanimous, all 9 justices agreeing, that sends a pretty strong signal, doesn't it? No dissenting opinions to offer alternative views.
None. It really underscores the reliance on established statutory interpretation principles and precedent over trying to divine a new policy direction from somewhat ambiguous legislative phrasing.
Okay, let's talk impact. What's the real-world legal significance of Helsinn v. Teva? What does it mean for inventors, for companies going forward?
Well, the significance is huge, primarily because it provides definitive clarity. It confirms, without a doubt, that the AIA did not weaken or narrow the scope of the on-sale bar. The old, stricter standard still applies.
So that means any kind of commercial deal involving the invention selling it, offering to sell it, licensing it to someone else who will sell it, like MGI, even if it's done under a strict NDA.
Starts the clock. That 1-year countdown to get your patent application filed begins the moment that commercial activity happens with a third party. It puts immense pressure on inventors to file promptly once they start down the commercialization path.
No more relying on confidentiality clauses to shield you from the patent deadline.
None whatsoever. So if you have to pick the single most important takeaway from this ruling, it's this. A commercial sale or offer for sale to any third party, even one sworn to secrecy, is enough. If that happens more than 1 year before you file your patent application, your patent can be invalidated. Confidentiality protects your business secrets from competitors, sure, but it offers zero protection against the statutory on-sale bar. The act of selling is the trigger.
Wow. That is crystal clear and has major implications, especially in fast-moving industries like pharmaceuticals or software, where you often need partners early on. It really forces a tough choice, doesn't it? You might need that early partner deal like Helsinn did with MGI to get funding or distribution sorted out, but this ruling says doing that deal means you absolutely must get your patent filed immediately, even if you'd rather wait for more data or keep things quiet longer.
It absolutely does. It shifts the balance. You have to prioritize getting that patent application on file the moment you cross the line into commercial offers or sales, even confidential ones. The secrecy of the deal won't save your patent rights if you wait too long. The clock is ticking from the moment money might change hands or rights are granted.
A critical lesson in patent strategy. Thanks for walking us through that complex case. Really appreciate you digging into those details with us.
My pleasure. It's a foundational case for anyone dealing with inventions and commercialization today.
Absolutely. And thanks to you for joining us on the deep dive. Until next time, keep questioning.
Thanks for tuning in to the full episode. If there's any topic or case law you'd like us to cover next, share your suggestion in the comments on our latest video. And if you found value in the podcast, don't forget to like, subscribe, and hit the bell icon to stay updated.